Weiss+Associates presents State versus State. Government gains its authority through the creation and application of laws, and those laws are made up of words. As citizens who must abide by those laws, it's vital that the laws are clearly written and narrowly defined so that the citizenry knows what is proper and what isn't. We at Weiss+Associates have stressed in a large number of educational videos how those in government have manipulated the meanings of words to gain power and control that they otherwise wouldn't have. The national government has created a second parallel nation in corporate form with its own language using words that have very different meanings than in the other nation. Terms like United States, U.S. citizen, U.S. person, and trade or business are prime examples of this wordsmithing where the definition in one place is very different than the definition in another. Also, terms like non-resident alien individual are created with the clear intent to obfuscate and misdirect. Now, let's look at another term that the national government has created that has two very different meanings, and that is the term state. Again, the difference deals with the two separate jurisdictions that define the term, and those two jurisdictions are the constitutional republic and the corporate entity also known as the United States. If you were born in one of the now 50 states of the Union, you enjoy constitutional rights as a sovereign in the constitutional republic. The Internal Revenue Service derives its authority from the corporate entity, and the definitions of the terms it uses are located in Title 26 of the U.S. Code. Let's take a peek at what the corporate entity has to say about the term state. That definition is located at 26 U.S.C. section 7701A10, where it states, "The term state shall be construed to include the District of Columbia, where such construction is necessary to carry out provisions of this title." Let's also look at the Code of Federal Regulations at 26 CFR section 31.3121E-1A, where it states, "When used in the regulations in this subpart, the term state includes the District of Columbia, the Commonwealth of Puerto Rico, the Virgin Islands, the territories of Alaska and Hawaii before their admissions as states, and, when used with respect to services performed after 1960, Guam and American Samoa." Perhaps most clearly stated was a letter from U.S. Representative Barbara Kennelly in 1996 to an American where she stated, "The term state in 26 U.S. Code 3121E specifically includes only the named U.S. territories and possessions of the District of Columbia, Puerto Rico, the Virgin Islands, Guam, and American Samoa." Title 26 is, of course, the Internal Revenue Code. Nowhere in these definitions does it mention the 50 states of the Union. That's because the corporate body doesn't include the 50 states. By definition, and the exclusion of any reference to the 50 states of the Union means that the 50 states are foreign states to the territorial jurisdiction of the national government, referred to as the corporate United States. These territorial states referred to in this regulation are clearly part of a distinct and unique jurisdiction that has no nexus with the constitutional republic, where the U.S. Constitution is the law of the land. It is well known that the states listed in this regulation are not part of the 50 states of the Union. They are territorial possessions of the U.S. Congress, and the U.S. Constitution is not law there. For more clarity, let's turn to a document that reflects wording used by the 63rd Congress in 1913. At the time, Alaska was a territory and did not gain statehood until 1959. Also, the Philippine Islands, the Marshall Islands, Palau, and Micronesia later gained independence. Here is a list of territories under the exclusive jurisdiction of the U.S. Congress: the District of Columbia, American Samoa, Guam, the Commonwealth of Puerto Rico, the Virgin Islands, Midway Island, Wake Island, the Commonwealth of the Northern Marianas, Johnston Island, Baker Island, Howland Island, Jarvis Island, Kingman Reef, Palmyra Island, and Navassa Island. Several of these are minor, outlying, and unincorporated islands and are largely uninhabited. Most people living here are deemed statutory U.S. citizens with the apparent exception of American Samoa. According to this NBC News article from 2016, an American Samoa native who served military duty in Kuwait cannot be called a statutory U.S. citizen, as it seems no one from that territory can be. The article states that American Samoans are referred to as non-citizen nationals. He was part of a group that sued the national government to be included as statutory U.S. citizens. The group was seeking clarity from the Supreme Court, which declined to hear the case. The article went on to state, "The Justice Department said U.S. territories are not in the United States within the meaning of the Constitution, so only Congress can confer citizenship, as it has for all territories except American Samoa." As Alaska and Hawaii successfully did in the 1950s, Puerto Rico is currently pushing for statehood status, which is also referred to in the Constitution as admission to the Union. Obviously, Puerto Rico is already a state, but isn't a state, if you get the reference. So the question begs a logical answer. Why would the national government use such language if it didn't specifically define a unique, singular thing, but instead created confusion by defining two different things with the same word? The answer lies in jurisdiction. Having a territorial United States allowed for the existence of dual definitions, and we can easily see that the national government used this duality of meanings to its advantage in coaxing sovereign Americans to unknowingly identify themselves as statutory U.S. citizens in gaining power over them that the government wouldn't have otherwise had. So when you identify yourself as a U.S. citizen on any IRS form, you're stating that you're a member of the United States as defined in the Internal Revenue Code to be the District of Columbia and its insular territories. You've also identified yourself as someone who's under the jurisdiction of the corporate United States, something that does not apply to the people born in the 50 states. Those born in one of the 50 states of the Union are known as non-resident alien individuals, and their IRS tax obligation is extremely limited in scope. Please see our video on Who are non-resident alien individuals? The link to that video is located in the show notes below. Also, be sure to check out our other educational videos on the terms United States and U.S. citizen. If you've mistakenly identified yourself as a statutory U.S. citizen and filed a Form 1040 individual income tax return, you can consider our revocation of election process, which is documentation that clarifies your true and correct status as someone who is not under the jurisdiction of the national government, with no obligation to file and pay the federal income tax. We have a link to that video below as well. You can glean more information by visiting our website, Weiss+Assoc, and email questions and comments to bilateral@gmx.com. Please smash the like button if you found this video informative and subscribe to our channel. Thanks for watching.